A legal mechanism exists right now that can strip you of your firearms in under 24 hours without you ever setting foot in a courtroom. No arrest, no conviction. Just a judge's signature and law enforcement at your door demanding you surrender every gun you own. Hit that subscribe button right now. What I'm about to reveal could be the difference between keeping your Second Amendment rights and losing them permanently. These confiscation mechanisms are spreading to more states every month. Here's what's happening. Extreme risk protection orders, also called red flag laws, are being implemented or expanded across America. As of 2026, 21 states plus DC have these laws. Under these laws, someone can petition a court to have your guns confiscated, and in many states, you won't even know about it until police show up. Let me break down exactly how these confiscation mechanisms work, who can petition to have your guns taken, what legal protections you actually have, and most importantly, what you need to do right now to protect yourself. Number 1, what extreme risk protection orders are and how they work. An ERPO is a civil court order allowing law enforcement to temporarily remove firearms from someone deemed dangerous to themselves or others. The process: someone files a petition claiming you're a danger. Family member, household member, law enforcement, or in some states, co-workers, school officials, or medical professionals. No proof of crime needed, just convince a judge you pose a risk. The court reviews the petition and can issue an ex parte order. Ex parte means you're not present, no defense, no lawyer. You don't even know what's happening. Judge reviews petition, finds probable cause, issues temporary order authorizing immediate firearm seizure. This initial ex parte order lasts 14 to 21 days in most states. Law enforcement can show up anywhere, home, work, and demand you surrender all firearms. Refuse, you're arrested for violating a court order. Lie about having guns or hide them, additional criminal charges. After seizure, you finally get a hearing within 2 weeks, but your guns are already gone. At the hearing, you must prove you're not a danger. Notice the burden shift. You're not presumed innocent. You must affirmatively prove you don't pose a risk. If the judge finds against you by preponderance of evidence, much lower than beyond reasonable doubt, the order extends up to a year. The issuance standard is incredibly vague. Recent threats, patterns of violent behavior, reckless firearm use or display, recent acquisition, or substance abuse. These criteria are highly subjective with enormous judicial discretion. If you're finding this helpful, imagine what you'll learn in my next video where I break down the exact legal strategies to fight an ERPO before your guns are seized. Subscribe right now because that video could save your Second Amendment rights when you need it most. Number 2, who can petition for your guns to be confiscated? Laws vary by state, but the trend is expanding who can file. Law enforcement can always petition. Any police interaction could potentially result in a petition if the officer thinks you're unstable. Family and household members can petition in almost every red flag state. Spouses, domestic partners, blood relatives, people who live with you. Think about weaponization, messy divorce, custody battle, angry teenager. All can potentially file ERPO petitions. Some states allow current or recent dating partners. Someone you dated briefly can initiate confiscation. More expansive, California, Oregon, Washington allow coworkers and employers to petition. Workplace dispute, you get fired. Former boss files ERPO claiming you seemed unstable. Some states allow school officials and medical professionals to petition. Serious privacy and due process concerns. Most concerning, in many states, no consequences for false or malicious petitions. No penalty for lying on an ERPO petition creates harassment incentive. Quick legal note. This is educational information about extreme risk protection orders and gun confiscation mechanisms. This is not legal advice for your specific situation. If you're facing an ERPO or any threat to your gun rights, you need to immediately consult with an attorney who specializes in firearms law in your state. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these critical legal updates first. Click that subscribe button right now because next week I'm covering the 3 things you should never say to police that can trigger an ERPO investigation. Don't miss it. Number 3, what happens during confiscation? You need to understand exactly how this unfolds. Scenario 1, ex parte order issued without your knowledge. Law enforcement shows up with court order to surrender all firearms immediately. What to do? Stay calm. Don't get confrontational, make threats, or resist. Everything you say or do will be used against you. Ask to see the court order. Read it carefully. Comply under protest. I'm complying with this court order under protest. I want to speak with an attorney before answering questions. Document everything: officer names, badge numbers, seizure receipt, photos, video if safe. Immediately contact a firearms attorney. You typically have only 14 days until hearing. Scenario 2, you receive hearing notice before seizure. Better situation. You can prepare. Attend hearing with attorney. Present evidence you're not dangerous. Character witnesses, medical records, safe storage proof, evidence allegations are false, don't show up. Judge likely issues order by default, then scenario 1 happens. Number 4, here's what you need to know about getting your guns back. Because even if an RPO is issued, it's not necessarily permanent. The initial order typically lasts 1 year. After that, it expires unless the petitioner requests an extension. To get an extension, they have to petition the court again and show you still pose a risk. You can petition for early termination of the order. The process varies by state, but generally you can ask the court to terminate the order before the 1 year period expires if you can show changed circumstances. This might include completion of mental health treatment, anger management classes, substance abuse counseling, or other evidence that you're no longer a risk. However, here's the harsh reality. Once your guns are seized under an ARPO, getting them back is difficult, expensive, and time-consuming. You need an attorney. You need to present evidence at a hearing. You need to convince a judge. And even if you win, there can be bureaucratic delays in actually getting your firearms returned. Worse, some states charge storage fees for holding your firearms during the RPO period. You could be billed hundreds or thousands of dollars just to get your own property back. And here's the most concerning aspect. In many states, if you're found to have violated the ERPO by attempting to purchase or possess firearms during the order period, that violation can be used as evidence to extend the order. You're caught in a catch-22. The order restricts your rights, and any attempt to exercise those rights is used as proof you should continue to be restricted. This information could literally save your gun rights when you need it most. Subscribe now because my next video reveals the 5 early warning signs that someone might be preparing to file an ERPO petition against you, and what you can do to prevent it legally. Number 5, here's what you need to do right now to protect yourself from gun confiscation under these laws. These are practical action steps every gun owner should take today. Action step 1, know the law in your state. Does your state have a red flag law? Who can petition? What's the standard for issuance? What are your procedural rights? You can't protect yourself if you don't know the rules. Action step 2, document your mental health and stability. If you're in treatment for any mental health issue, make sure you're compliant with treatment and your provider documents your stability. If someone files an ERPO petition, you'll need evidence to refute it. Medical records showing you're stable and not a danger are powerful evidence. Action step 3, be extremely careful about what you say and post on social media. Anything you post online can be screenshot and used in an ERPO petition. Angry posts about the government, screenshot. Frustrated comment about your ex-spouse, screenshot. Photo of you at the range with the caption, "Ready for anything?" Screenshot and present it to a judge as evidence you're preparing for violence. Action step 4. If you're going through a divorce, custody battle, or any contentious personal situation, talk to a firearms attorney proactively. Don't wait until an RPO petition is filed. Get ahead of it. Your attorney can help you document that you're not a threat and prepare a defense in case a petition is filed. Action step 5. If you receive notice of an ERPO petition or if police show up with a court order, immediately contact a firearms attorney. Do not try to handle this yourself. Do not think you can talk your way out of it. You need professional legal representation immediately. Action step 6. Never violate an ERPO, even if you think it was wrongly issued. If a court order says, surrender your guns, surrender them. Violating the order gives them ammunition to extend it and can result in criminal charges. Fight the order in court, not by defying it. Here's the bottom line. Extreme risk protection orders are a legal mechanism in 21 states that allows for confiscation of firearms without criminal charges, without arrest, and in many cases without you even knowing about it until police arrive at your door. The process is designed to be fast, the standards are vague, and the burden shifts to you to prove you're not dangerous. These laws are expanding. More states are considering them. Some states are broadening who can petition. The trend is toward more confiscation authority, not less. Whether you think these laws are good policy or unconstitutional overreach is irrelevant. They exist. They're being used. And if you're a gun owner, you need to understand how they work and how to protect yourself. The states currently with red flag laws include California, Colorado, Connecticut, Delaware, Florida, Hawaii, Illinois, Indiana, Maryland, Massachusetts, Michigan, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, Virginia, Washington, and the District of Columbia. Several other states are considering similar legislation. If you live in one of these states, you are subject to these laws right now. If you live in a state without these laws, watch your state legislature because these laws are being pushed nationwide. Look, I spend hours every week researching firearms laws, reading court cases, and analyzing legislation so you understand what's actually happening versus what the media claims. The least you can do is hit that subscribe button to make sure you never miss a legal update that could cost you your rights. Subscribe right now. Share this video with every gun owner you know because most people have no idea these confiscation mechanisms exist. The more gun owners understand their rights and the legal risks they face, the better we can protect the Second Amendment. Remember, this is educational information about extreme risk protection orders and gun confiscation laws. It is not legal advice. If you're facing an RPO or any legal threat to your firearms rights, immediately consult with a qualified attorney in your state. Stay informed. Stay vigilant. And for God's sake, be smart about what you say and do, because in 21 states, your words and actions can result in your guns being confiscated without criminal charges. Thanks for watching. I'll see you in the next one, where we break down the exact legal defense strategies that work in ERPO hearings.